So we're now on to slide 24, so the Australian legal system. And this part of the lecture will start to talk about our particular system and how it operates. So the Australian legal system is characterised on these 3 dot points. So we are a representative democracy, meaning that individuals are elected to represent us as people, and they're the ones that make the laws for us. So we think about parliamentarians or politicians. They're representative of the people that elect them in. Well, they should be. So we're a democracy based on a common law legal system. So we've got a statute, and we've got statutory law, and we've got case or judge-made law. And one that's a bit unique is that we're this constitutional monarchy. So that means that we have this constitution that establishes or underpins the legal system. And in fact, the Queen is still the head of our system, which is a bit funny because the Queen is from the UK. It's a bit historical. Now, it still is connected, though, the Queen in Australia. So who is the representative for the Queen in this? Yep, that's it. The Governor-General is practically, for all intensive purposes, the Queen. So under the Constitution, the monarchy is still the head of state, even though the Prime Minister arguably is the one that's got all of the, at least, visible power. And then the Governor-General is the representative for the Queen, but to be honest, that role is probably more ceremonial than anything. So they do have some powers around convention and the like, but what their real role is to stamp the law and give it royal assent. So historically, the Australian legal system, if we go all the way back to 1788 when the English settlers first came, now we can even go a little bit further back in terms of, I think, the 1500s, where the UK Parliament passed legislation that enabled them to commute death sentences to getting off the English island. So instead of being sentenced to death, the prisoner could agree to be settled in a different country or continent. So in 1788, a lot of these UK prisoners, the first settlers, came to Australia. And because they believed that the land didn't have any existing laws, they established the legal system on a concept of terra nullius, which means that because there's no laws there, the English laws are automatically transported and brought there. Now, the question then is, what about the Indigenous peoples? So prior to the English settlers, we did have Aborigines or Indigenous Australians living on the continent. And this meant with the, transferring or transportation of the English law, that a lot of them lost their land rights. So there's a big case, Mabo and State of Queensland in 92, which was a really powerful case for the Indigenous people, and it said that not all their legal rights were extinguished by this concept of terra nullius. So the Indigenous people still have certain land rights that were not extinguished by UK rule. That's an incredibly important underpinning principle of our Australian legal system. But for everything else, we follow the UK legal system. We've got a bit of history on there. I don't think you need to know all of it, but some of the important stuff is in 1828, the UK passed acts that enabled each colony to formulate its own law. So if we're thinking about the first settlers, we had colonies in New South Wales, some in Victoria, Tasmania. You can see the states starting to form. Then in 1850, the UK government gave those states the power to have their own constitutions and their own powers to pass their own laws. But they're still very tied to the English way. Now, it wasn't until the Constitution that Australia became its own federation. What's interesting, though, is the Constitution is actually an act of the UK, giving us the power to do what we do now. And then eventually we broke all ties in 1986. So it wasn't until 1986 that British law could still apply. And then in 1986, under the Australian law, under the Australian Act, we broke all of that. What's important, though, is that UK law still is good law in Australia if it hasn't been overwritten by our own law. So the Statute of Frauds is a really good example of an act from the UK that's still law in Australia. Don't worry too much about the historical timeline. I think it's more something you can pick up from reading the textbook, but it's just good to know in the background. So our system is built on a separation of powers. And the three powers that we have is one, the judge, the judiciary, so the courts. We've also got Parliament, and then we've got the executive. And the purpose of this separation of powers, as we discussed in the rule of law, is to make sure that not one body has all of the powers, so they're not above the law. So the judiciary, the courts, they hear cases and make judgments. That's their role. Parliament's role is to create legislation, which becomes law. And then the executive are the individuals that put the law into practice. So if we think of the executive, we can think of the police, for example. They are exercising executive powers. Now, what's a bit unique, though, here is that the executive are also politicians that are elected. So ministers, for example, are those individuals that are administering the laws that they're responsible for. So you might be the Minister for Education. You're then responsible for that parcel of law. But we can see there automatically there's a little bit of a grey then here, isn't there? Because politicians are also parliamentarians, so they pass legislation as well as administer legislation. So there's a slight blurring of our separation of powers there. But at least we can say the judiciary is independent insofar as who elects the judges. The executive. Eventually, they appoint judges to that role. So, yes, we've got a separation, but there's always this blurring. But in saying that, I think our system is still effective because there's not one body that has all of the power. Yes, they can influence each other, but the main premise of a separation exists. The separation of powers is incredibly important to understand what each body does. So then under that we've got 3 levels of lawmaking. The first level is our local level called the council. So if you live in a suburb, you will have a local council that governs that area. So there's approximately 537 local councils around Australia. And they all have what we call bylaws. So laws that are in relation to the keeping of domestic animals, laws around rubbish removals, permits to build, a lot of the domestic stuff. But they are laws that they can make. Just above the local council, though, we've got the state and territories. So there's 6 states and 2 territories and a bunch of external territories. But where the local councils are getting their power from is the states. So each state has a constitution, and then those constitutions in those states pass laws that enable the councils to have laws. Then above the states, we've got the Commonwealth of Australia. So that's the federation that we have. Now, the powers between the states and the Commonwealth are really set out in the Constitution, because there are still some elements that the states have residual powers that the Commonwealth can't interfere with. So although we've got this concept of a federation with a Commonwealth up here, there's still some competition in terms of who's got power in certain areas. And I'll explain that as we go through. The other thing about our system is this concept of responsible government. And this is a term used to describe a political system where the executive government is drawn from and are accountable by the Parliament. So in practice, this means that the Parliament is responsible to the people that voted them in. Whether that is the case in practice, but it's how this system is operating is that you're responsible to your electorate. Now, responsible government, I guess it's important to note how a government is formed. Generally speaking, it is the way it goes. If you've got a party who has the most percentage in a house, the lower house, you've got a government. So right now the Liberal Party is the government. And when you've got a government, you've got the Prime Minister being from that area. Now the Prime Minister role is not something that's captured in the Constitution, it's something more of a convention that we've inherited. But the Prime Minister is pretty much the head of the government and the one that you see doing most of the talking and decision making by the looks of it. But the Prime Minister is not the head of the state, the Queen's representative is. It's just that they don't really exercise any powers other than what's given to them under the Constitution. So in our Parliament, we've got a House of Representatives and a House called the Senate. There's two different houses. To pass legislation, you've got to go through both. And we can say that the Senate's more based on representatives from the states, so let's try and balance that. Whereas the House of Representatives is more balanced on electorates being zones. Sorry, what was the question? That's a great question. In terms of the language that we're using, is we keep saying states. States can mean two things. First, it can mean Victoria, Queensland, New South Wales. But we also, and unfortunately this is probably an error on my behalf in terms of that description, but nations are also states. So we can say that the state, when I was explaining, it was Australia. So Australian system, we've got a Prime Minister and a Governor-General. In each state, we'll have a Premier, and similar to a Governor-General under their constitutions. Which can be a bit confusing, and we'll get to that when we get to the Constitution. Which is now. The Constitution, the most important piece of legislation in our framework. In 1901 it came into force, and what it really does is codify the separation of powers. So you can see from the chapters of the Constitution, our three bodies. The Parliament, the Executive Government, and the Judicature. This is giving those bodies the power to do what is being given to them under the Constitution. So the Judicature, the judges, the courts, have the power to hear cases. It's given to them by the Constitution. And then there's some other chapters on the states and how they're formed. And lastly, which is important for us, is Chapter 8, how do we change the Constitution? Has to follow a very specific process. And this is unique to the Commonwealth, whereas the states also have another constitution themselves. They can just change them by passing law. To change the Australian Constitution, you need to go through what's called a referendum, which is a whole voting process. So a bit different, and I'll explain that in more detail shortly. So the separation of powers between not just the executive, judicature, and Parliament, but we've also got a separation of powers between the states and Australia as a Commonwealth federation. So the way the Constitution is set up is that only powers that are given to the Commonwealth are the powers that they have. If the Constitution says nothing about something, Commonwealth doesn't have powers to pass laws in that area. If they were to do so, it would be unconstitutional, ultra vires, beyond their own powers. And examples of those are laws in relation to education, for example. That is something that is residual to the states. So if the Constitution doesn't give that power to someone, it stays with the states. Because let's think about how the Constitution was formed. The states were already there. They existed before the Commonwealth. They then just decided to join together for some good reasons. First were the Germans and a bunch of other countries were starting to set up bases pretty close in the north. Secondly, individuals were able to, I'll take a step back, each state had a different immigration framework. So you may not have been able to enter the country in Queensland, but you could come in Adelaide, in South Australia, and then just go anywhere in the continent anyway. So the states were thinking, let's just have a federal system so that we can have uniform laws where we need it. But I think that's a really important factor of the Constitution, is that the states created it. And in their mind, they were still trying to hold most of the power of how the system was to operate. They were just trying to create a uniform picture that meant that everything around trade, customs, even the size of the railway tracks were uniform across the country. So anything that wasn't put in the Constitution, we call a residual power. Stayed with the states. However, anything that's in the Constitution, and it's something that is exclusively in the Constitution to be given to the Commonwealth, is an exclusive power. And if it's been exclusively given to the Commonwealth, the states can then no longer pass laws in relation to those subject matter. Some examples: defence. The states do not have the power to raise their own army without permission. That makes a lot of sense. Similarly, the states can't pass laws in relation to currency or the establishment of territories or customs. Those are exclusive powers under the Constitution. The way that they've been written in is exclusive. But then we've got something in the middle called concurrent powers. And these are powers that the Constitution gives to both the Commonwealth and the state. So in this middle column, both the federal government and the state governments can pass laws in relation to these areas. But what happens if the laws are inconsistent? And this happens. So this is incredibly important. 3 different powers. Exclusive powers belong exclusively to the Commonwealth. It's good to know what type of powers exist there. Concurrent powers subsist in both the Commonwealth government and the state government. And then anything that's not in the Constitution is residual with the states. They retain that power. Now, the only court that can interpret the Constitution is the High Court. And what we've seen over time is that when cases come up in terms of who has the power to do something, the High Court has slowly or gradually whittled the state power away. So this is why we see now such a higher, focus on the Commonwealth being the predominant lawmaker. And it's not just the High Court interpretations, it's also the ability for the Commonwealth government to control the purse strings. So the money that goes to the states. And I'll explain that. So Section 51 is where we can find our 39 heads of power. That's important to know. Section 39, if you ever go look at the Constitution, that will show you the 39 heads of power in terms of whether the states and the Commonwealth can pass laws in relation to that. And that's the important part, is that the Commonwealth legislative power is limited to that granted in the Constitution. If the Commonwealth is to try and pass a law that they don't have the power to do, the states will then bring a case in the High Court and say that that's ultra vires and unconstitutional. And we've seen a bunch of battles in the past in relation to that. So notwithstanding that the powers, we're talking about concurrent powers here, are given to both in Section 51, if the federal parliament decides not to legislate in that area, it just means that the states are free to do what they like, so long as it's a concurrent power. This is not an exclusive power. And this is when we get to that inconsistency problem. The Commonwealth may decide to pass a law that they have a concurrent power in, which is inconsistent with a state law. So the writers of the Constitution determined that the Commonwealth provisions would prevail to the extent of any inconsistency. And the section that tells us that is section 109. So if the Commonwealth passes a law that's inconsistent with state law, the Commonwealth law takes precedent or is more important, and the state law then becomes not valid, technically. This is when you'll see most of the disputes, because the states will say, hey, you've just grabbed our power. That's unconstitutional. But why it's important is in practice it can mean very different outcomes. An example here is the Wallace and Downwood-Pickford case, where we've got a transport company or removalist company that's transporting goods, and as part of that transportation they've damaged those goods. Now there's two different laws around compensation, and unfortunately they've got very different compensation amounts that are calculated based on the interpretation of those laws. Under federal law, Wallace was entitled to compensation of around 1663. But under the Queensland laws that had the same provisions, not the same provisions, but the same in the same area of power, were only $200. So you can see here automatically that the removalist company wants to say Queensland law applies, but the poor guy that's had his equipment damaged wants to say that the federal law applies because he's going to get more money. It's a real-life example of that inconsistency. And because of Section 109, he was able to get the federal amount because it prevailed. That's a good example of the High Court also being favourable to the Commonwealth. So how do we amend the Constitution? It's incredibly hard. And this process is really important to you. So since 1901, we've only had 8 out of 44 referendums being successful. What a referendum is a proposal to change a provision of the Constitution. So to get an amendment through, you need to first pass the amendment through both houses, and that's the House of Representatives and the Senate. So it needs to be pretty popular in terms of the government of the time. And then it also needs to be voted on by the public. And the vote from the public's perspective has a very high double threshold. And this can be a bit difficult to explain, so stop me if it doesn't make sense. But you need to show that at least over 50% of the voters in Australia said yes to the change. The second aspect is you need to show that in a cumulative way that a majority of the states said yes. So let's say we've got 6 states and 2 territories. If on the balance 5 states said yes, and a majority of the voters being over 50% said yes, you'd have that passed in a referendum. But that can be challenging though, because obviously some states have more population than others. So you might have, yes, a majority of states, but they might be the little states, and actually a majority of voters said no because the eastern coast has most of the population. So only 8 times have we seen this double majority being met. So it's not many. One of them being change in 1967, when they changed the Constitution to allow the Indigenous people to be counted as part of the population. So that was a good one to get through, a big one. But a big one that we know that has failed in the past is the referendum to become a republic. What that means is we separate ourselves from the Queen and would operate similar to a president kind of system. That wasn't successful. The referendum didn't pass. That process is incredibly important for you guys. And what section gives us that process? Can anyone remember? It's in chapter 8, 108. So a summary of the Constitution. It gives us the fundamental rules I won't call them rules, I'd rather call them powers. It gives us the fundamental powers that those bodies can exercise. And what the Constitution does is then, by that, govern the state being the nation of Australia. And we know that there's more than one constitution. We know that this is the Australian Constitution for the Commonwealth, the federal government, but each state will have its own constitution with its own rules that govern it. We're just going to concentrate on the Australian one because I don't think we need to go through the Victorian one as well. Just focus on the federal. This was in 1901. Section 51, incredibly important to you because it allocates the legislative power in terms of those heads of power. Exclusive powers belong exclusively to the Commonwealth, such as a power in relation to passing laws for defence. Concurrent powers are shared between the states and the Commonwealth. And these are set out in Section 51. So the exclusive powers will have language that tells you that it's exclusive in comparison to the concurrent ones. And anything that's not in the Constitution is residual power to the states. So the states pass laws in education, health. Our criminal acts are state-based law. But what we've found is those residual powers are now controlled significantly by the power for the Commonwealth to give grants, for example. So let's say the Commonwealth wants to make the state build a road. They won't give them any money until they agree to build that road. So although the states have the residual power, their hands are a bit tied when it comes to that type of situation. Taxes. We saw that that's a concurrent power, but how often do we pay taxes to the state? Yes, there's some examples, such as when you die, you pay tax to the state. When you buy a house, you pay stamp duty. But income tax used to be a state thing. And what happened was, during a time of war, the Commonwealth in the 1940s wanted to get more money to fund that war effort. So they got the states to refer some of the power to them to let them get more taxes, because it wasn't very attractive to have a state tax and a Commonwealth income tax. Who wants to pay double tax? You get a little bit. But then when the war ended, the Commonwealth refused to give the power back. So the states were stuck. They couldn't then raise their own income taxes. So then the Commonwealth, they just go, all right, we'll give you money back, but it'll be tied to some sort of requirement, such that you build a hospital, that you do something we need. So you can see how the Commonwealth can control the residual powers through money. The other thing is the Commonwealth are getting more and more power through the High Court interpreting the legislation. And a good example of this is the Tasmanian dams case. Anyone familiar with the hydro dam in the Franklin River in the 80s? This is a good example of the states and the Commonwealth having a bit of a dispute over who's got power. So the state of Tasmania wanted to build a hydroelectric dam for the purposes of generating electricity. But what that would have meant is a significant disruption to the Franklin River, a big excavation, and probably a destruction of that natural environment. What had happened, though, is the Commonwealth had, under their external affairs power, which is under Section 51, so we can see it's concurrent, they've signed up to a World Heritage List treaty, in a way. And as part of that treaty, they've then made the Franklin River section a World Heritage listed natural wonder that can't be disturbed. So what they've done is directly encroach on the Tasmanian government's ability to develop this hydroelectric dam. So they've signed the treaty, then they've passed laws around the environmental protection. Tasmania then took the case to the High Court, saying, well, actually, that's unconstitutional. They've just taken our power. The High Court interpreted the foreign affairs power so broadly that it included this concept of signing treaties, because that's a foreign affairs type of activity. So the Tasmanian dam case is a very good example of the High Court giving power to the Commonwealth through interpretation of those powers. Any questions about the Australian legal system so far? I know it's late. I do apologise. We've got a bit to get through though. So we're moving on to statutory law and the rules of interpretation. I will note that I am going through quite fast. So if you do have any questions, please let me know. And after class, if you have any questions, please let me know. Because sometimes when you're going through the textbook or the readings, you go, this makes very little sense. Feel free, because I understand we're going quick. So, statutory law and the rules of interpretation. So, a statute or legislation, they're the same thing. What these are laws made by Parliament. They're acts of Parliament. So, in our legal system, we have two sources of law, being legislation and judge-made law. Legislation can overrule a court decision, so it's held at paramount. It's more important. Now, we know they interrelate, though, because the courts will interpret legislative decisions, but to the extent of any similarities when we don't have, or inconsistency, legislation prevails. There's a video on how laws are made, which I won't play now, but in your own time, I do recommend having a look at those. They're published on Canvas under the supporting media materials, and you'll find a bunch of different things. But in brief, what will happen is a member will raise a bill, which is kind of the start of a law, and they'll pass it into generally the House of Representatives first. It'll get read a few times, they might make some amendments to it, and it'll get voted on. And if it's passed, it moves on to the next house. Once it gets through both houses, now sometimes it can be changed and then sent back and has to be voted on again. But once it gets acceptance from both houses, the Senate and the House of Representatives, it isn't law yet, but once it gets the stamp of royal assent from the Governor-General, it becomes something that is binding, legal. Usually they might have a bit of a clause that says when the act will commence. So hopefully the government's going to give you a couple of months to prepare. Sometimes it's not long. But if that's not the case, then generally it'll be the royal assent date. You don't have to be too across the legislative creation process, but it's just important to know that two houses needs to go through both. And those houses are politicians. So when we're looking at legislation, this is generally what the title will look like. So here we've got the Competition and Consumer Act 2010, and in brackets CTH. It's incredibly important that you understand how to read this, because that's what you'll use to reference legislation, but also identify them. So here we've got what we call the short title, the Competition and Consumer Act. It's short because it's just a snippet of what they call the long title. Now, the long title will be probably one of the first paragraphs that says, this is an act for the da-da-da-da-da-da-da-da. It's long. But our short title is our identifier, Competition and Consumer Act. Then we have a date. The date tells us what year it was passed, so what year it was made law. And then the brackets here tell us what jurisdiction this law has come from. Because we know that the Commonwealth has a jurisdiction under the Constitution, but the states also have a jurisdiction under their own constitutions. So the word CTH means that it is a law that's passed by the Commonwealth. If it's a law that's passed by Victoria, we'll see VIC, and that identifies that it's a Victorian law. Or Queensland, QLD. New South Wales, it tells us what jurisdiction it's come from and whether it applies to us. If we're in a Victoria and the New South Wales law is around traffic offences, it's not going to apply to you driving in Victoria. So that jurisdiction is really important in terms of, well, what law actually applies to me. But if you're a Commonwealth law, every state and territory has to follow it. Now for us, the hard part is actually interpreting what the statutes are trying to say. Statutory writing is notoriously bad with a lot of acts having terms that are hard to determine what they actually mean. And interpreting any words, let's even think of it from a contract perspective. I've seen a lot about contracts. So you sit there and you go, I have no idea what this person was trying to do at the time. But someone's got to try and interpret it. We all interpret things differently though, don't we? Which one of these is a pet? Has anyone got a pet ferret? Or had a pet ferret? Does anyone think a ferret isn't a pet? What about goldfish? Pet, generally? Yeah, probably most of the time. A puppy? Yep. What about the gigantic python? Who thinks that's a pet? Some would. Some wouldn't. So we all interpret these things differently, and what we're looking at here is this word pet. If we were to just see the word pet in a legislative instrument, we're left with all of this room to interpret what that actually means. Could mean a lot of different things to different people. So what is the law when it says you cannot keep a pet outside after 9 p.m? The courts have then got to go there and say, what was the Parliament trying to do? So we have these rules of statutory interpretation. The first one being, and the most important one being, the literal rule. And what that means is that we just take the literal definition of that word. You can open the dictionary and find out what that word is described as. And you give it the technical definition. But the problem there is that that can sometimes result in quite absurd outcomes. Let's see this sign that you're about to cross a street intersection, and you've got a sign that says don't walk. If we interpret that literally, does that prevent me from running? Does that prevent me from crawling? In a literal approach, I can run across the road because I'm not walking. So you can see that that literal interpretation doesn't always work. So the courts have a bit of an out. We always try literal first. And if it doesn't work, we go to the golden rule. It provides an escape. So the courts could see this and say, well, yeah, you can't run across because you're going to get hit by a car. What we're going to say is that just means you can't enter into the intersection when that is lit up. So a good example is the Sigsworth case, where unfortunately we had a son that had murdered his mum. And if we look at the laws around intestacy and wills at the time, it meant that I'll take a step back. The mother hadn't written a will at the time. She just hadn't had time to it, and she was murdered by her son. And the laws in England at the time meant that if you didn't have a will, your money went to the next of kin. So even though he murdered that poor lady, he was in line to inherit all of her money. Well, he was going to go to jail anyway, but the court interpreted that provision, though, to say that that's an absurd result. You can't get access to that money under the Act because you're the one that pulled the trigger. So they interpreted that Act using the golden rule rather than the literal rule. In saying that, we've got some further principles that we use. Remember, literal first. If that doesn't work, golden rule. But we've also got this concept of mischief and purpose rule. Interpreting with the mischief in mind is thinking, what was the Parliament trying to fix? What was the wrong that they were trying to prevent? So if we've got that sign that says don't walk, the Parliament is trying to create a situation where people aren't crossing an intersection dangerously. So using the mischief approach, we know that sign meant pretty much don't enter the intersection. It's very similar to the purpose of approach, which means we take a step back and we look at, well, what was the purpose in mind when the Parliament passed this legislation? What was their purpose? Now, generally speaking, that will be aligned with the mischief, but sometimes it might be a little bit different. So the mischief purpose might say, yep, you can't enter the intersection because the sign says don't walk. And the purpose of that was to try and stop individuals from entering the intersection dangerously. But the purpose might have actually also been we didn't want so much traffic in that zone at the time in terms of foot traffic. So it's a little bit different in terms of how it might be applied. But in saying that, the purposive approach is, in my opinion, always the best approach. What was the purpose? Now, we even have an act called the Acts Interpretation Act, which helps us interpret acts. And most acts will have a definition section or a dictionary section that will help us to identify what certain words mean, including that circumstance where we've got a pet. They might define what a pet is to be a certain range of animals. Maybe they define a pet to be a domestic animal of a certain kind, but then we've still got the problem of what is a domestic animal. So first literal rule, second golden rule, and then you use the mischief or purpose rule. Even though I believe purpose is the best, we've still got to start with the literal rule. And onto that example of the pet and a definition saying it's a domestic animal. We've then got these things called maxims that can allow us to further drill down what the meaning of that word is. And this is going to sound a bit like a Harry Potter curse, but one of them is the Est Judum Generis rule, which pretty much means that you interpret those words based on preceding specific words. So we've got the pet, and a pet is a domestic animal. And then we could put some examples in there to say a domestic animal is a cat, a dog, a sheep, maybe a goat. But what we know from that specific list of animals that it's unlikely to be a lion, a tiger, or a bear. We're limiting that interpretation based on the generic or generis or general class of those words. So here we've got gin, brandy, whiskey, and other drinks. We can see that the general class of those words is alcoholic drinks. We know then that it's unlikely to include tea, coffee, or water. The legislation is designed to address those specific drinks that are alcoholic in nature. We've then got some further maxims, such as the nociter associate. I don't even know how to say that. Where you take the bigger picture in terms of how a word is interpreted. And an example could be, let's think of a contract that was written for a lease. And in that lease, they were talking about a food market. Now, there's some legislation around the difference between a food market, well, not difference, but around supermarkets. The fact was that that food market could be interpreted to just be a supermarket. Same thing. We've also got these principles that later legislation overrules earlier inconsistent legislation. So if you've got acts that are in the same area, this is very rare, but the later legislation, that interpretation will always take precedence over the earlier. There's two different tax acts, 1936 and I think 1997. Might be an example of when we might see that. It's also important that if something is very specific, those specific provisions will override any general provisions. So if you've been very specific in a contract in terms of certain things, and then all of a sudden you start being general, the courts will be like, oh, it's specific, we're going to interpret with focus on what you brought earlier. And then we've also got the expressio unius est exclusio alteris, which really does sound like a Harry Potter curse. But that's that concept that if it hasn't been expressly mentioned, well, does it exclude all other things? And this sign says no shirt, no shoes, no service. And the guy is not wearing any pants because he's like, well, it doesn't say anything about no pants. But the fact that you've started expressly mentioning clothes, and we can interpret that to mean a dress code of a certain kind, it would be a bit outrageous to suggest that that could be interpreted to also mean no pants. It's a really good summary snapshot that you can have in terms of the different statutory interpretation rules. These are useful in terms of when you read the legislation and also when we get to contract terms. But as way of recap, always start as a literal rule. What is the literal meaning of that word? And if that creates a circumstance that's a bit weird or not working, go to the golden rule and then the purpose of approach.